I think beneficiary designation forms can be totally confusing. How should you fill them out? And who should you name as your beneficiaries anyways? Mistakes here can lead to unwanted taxes or even force your assets into probate. This is a hassle that nobody wants to deal with. In today's video, we'll demystify the process of updating your beneficiary designation forms for your retirement accounts. We'll cover the different types of retirement accounts, how to correctly name the beneficiaries, and crucial pitfalls to avoid to ensure that your hard-earned savings go where you want them to go. So let's dive in. There's a lot of retirement accounts out there. 401ks, 403bs, regular IRAs, SEP IRAs, simple IRAs, Roth IRAs, the list goes on. When you set up a retirement account, the entity usually asks you to fill out a beneficiary designation form. This is where you state who should inherit the money in the account when you die. You can name a primary beneficiary. This is who you want to inherit the account. And then you can also name a secondary beneficiary or a contingent beneficiary. So that's like the backup person in case the first person you named has passed away or is no longer able to inherit that account. You can fill out a beneficiary designation form not just when you set up the account, but really anytime at all. You can also name multiple people as beneficiaries, and you can assign them each the percentage of what you'd like them to receive. But I caution you to make sure that those percentages total 100%, because if they don't add up to 100%, the entity might find that the entire beneficiary designation form is invalid and it doesn't apply. I heard this happen once where 3 children were named as beneficiaries, but the person who filled out the beneficiary designation form didn't do the math right, and they gave each child 30%, which totaled 90%. But what happened to the extra 10%? It didn't say, and the entire designation form failed. So in that case, sometimes you can name, a third, but sometimes they make you type out numerically what percentage. So if you're naming 3 kids, you'd want to name 33.33% for one of them, and then the same for the second one, and then maybe 33.34% for the third child, because it all needs to add up to 100%. So please keep that in mind. You should note that you should not retitle a retirement account in the name of the trust. We do have you retitle bank and brokerage accounts in the name of your revocable trust, but not retirement accounts. For retirement accounts, you keep them in your name, and then you name beneficiaries, and that's how it passes, as opposed to passing because it's held in the trust. If you change the ownership, all the taxes can become due, and we don't want that. Also, if you mail in a beneficiary designation form, please follow up with them to make sure that they actually received it and that it applies. I've heard of cases where people mailed in beneficiary designation forms, but they never arrived at the entity and they found that it didn't apply, and that was a big mess. So what happens if you don't fill out the beneficiary designation form, or the person that you name as beneficiary is deceased, or the entity decides that the designation form fails, anything like I've described, or the percentages don't add up to 100%, then the retirement account would pass through your estate. And this means that it would go through probate. And this is a horrible, horrible process in California. In fact, I did a video called 10 Things I Hate About Probate. So go ahead and watch that and tremble with fear, and then go and update your beneficiary designation to make sure that doesn't happen. Those are the basics of beneficiary designation form. So let's talk about who you should name as beneficiary. If you have a 401k plan, for example, that plan is covered under ERISA, which is the Employee Retirement Income Security Act, and certain rules apply. For example, if you're married, you're required to name your spouse as the primary beneficiary of your retirement account, at least here in California, unless a spouse signs a waiver saying that somebody else can inherit first instead. That doesn't apply for regular IRAs and SEP IRAs and other retirement accounts that are not under ERISA. And please also note that when I'm talking about tax implications, we're talking about everything except for Roth IRAs, where the taxes are already paid and taken care of. So if it's not under ERISA, or even if it is, you would name the beneficiaries. You can name an individual, you can name a charity, or you can name a trust as a beneficiary. But please don't name your estate. That makes the account go through probate, and we don't want that. Some people, particularly some financial advisors, think that you shouldn't name trusts as beneficiaries. And I'm going to explain to you why they might say that and why I think they're wrong. To explain this, we have to dive into something called the Secure Act. So the Secure Act was passed at the end of 2019, and it changed a lot of rules relating to retirement accounts. It essentially makes things a lot better for folks who are retiring or have already retired, but worse for those inheriting those accounts. Before the Secure Act, for example, if a child inherited a retirement account, they could stretch out the benefits over their lifetime and only pay income taxes on the required minimum distributions based on their life expectancy. So let's say that they were expected to live 40 more years. They only had to withdraw 1/40th of the account each year and pay taxes on that 1/40th. So this is a good way to kind of postpone paying those income taxes. But after the Secure Act, the child does not have that opportunity anymore. When they inherit a retirement account, they only have 10 years to withdraw all the money and pay all of the taxes. Wow, 40 years compared to 10 years. Not such a good deal anymore. But there are some beneficiaries that still get to stretch out the account over their lifetime. I want to share a chart that goes into which ones do and which ones don't.
Hey everyone! If you like my mom's video, like and subscribe.
Okay, so under the Secure Act, there are some people called eligible designated beneficiaries, and then there's other people who are not, so they're called designated beneficiaries, and then there's non-designated beneficiaries. Eligible designated beneficiaries, they get to stretch out the inherited retirement account over their lifetime. And those are, if you name somebody who's a minor under age 21, up till age 21, they get to stretch them over their lifetime. Once they hit 21, they have a 10-year window to withdraw all the money and pay all the taxes. A spouse can still inherit a retirement account and stretch out the benefits over their lifetime. So that's good. And a disabled person. We work with a lot of families, children with disabilities, and they can name their disabled child or the Disabled Child Special Needs Trust as a beneficiary and stretch out the benefits over that disabled person's estimated lifetime, and then the trust only needs to withdraw required minimum distributions. So it's actually really good nowadays to name a disabled child as a beneficiary or special needs trust. Also, if you have a beneficiary who's less than 10 years younger than you, like maybe a sibling, you can name them and they still get to stretch out the benefits over their lifetime. And also a chronically ill person, as defined by the IRS, they can stretch out the benefits over their lifetime. But basically everybody else who's an individual does not get to do this. Non-spouses and anyone else who's not an EDB. That's a whole lot of people. And then finally, for a non-designated beneficiary, the rules are the same as before the Secure Act. So if you name a trust like a dynasty trust, for example, and we have videos on dynasty trust, call that an accumulation trust where you're not required to distribute out all the income all the time, okay? It's the trustee's discretion, so the income can accumulate. In that type of situation, the trust only has 5 years to pay all the income taxes and distribute out all of the assets. That has not changed. So, should you name a trust as a beneficiary? Well, it depends. If you're naming a special needs trust, because the beneficiary of the special needs trust is an eligible designated beneficiary, then yes, it's a no-brainer. You should definitely be able to name a special needs trust and you get those wonderful stretch out benefits. But what if you're naming a neurotypical child as a beneficiary? Should you name the child themselves or should you name their dynasty trust? I suggest that you weigh the pros and cons, okay? If you name the child outright, then they have 10 years to stretch out the benefits and pay all the income taxes. If you name their dynasty trust, you have 5 years to pay all the income taxes and stretch out the benefits. So it seems like the dynasty trust is the loser here. However, dynasty trusts have some great protections. So if you don't think that your child is really up for inheriting the money outright, or if you just want to build in more protections for them, because dynasty trusts have great protections against spouses and against creditors, you may choose to still name the dynasty trust, the accumulation trust, as the beneficiary. You can still do that in order to capture those protections. So I hope this video has provided a lot of food for thought on how to update your beneficiary designations. So please Go update those beneficiary designations. It's never too late. Well, until you're gone, that is. And if you have questions about this, and if you'd like to review your designation plans along with your estate plan, please reach out to our office and we'd be so happy to help you.
Hello everyone. If you liked my mom's video, don't forget to like and subscribe. See you all next time.